This conference will now be recorded.
So thank you very much, all of you, to be here. This is a webinar which is organized, has been designed first in the context of eShape, and I will explain a little bit why we arrived to the idea that this webinar would be useful. And as you know, we consider that the eShape community is representative of the global Earth observation community in Europe. And so we have opened this webinar to everyone very recently. I will share my screen for a small introduction before giving the floor to our experts. So this meeting is recorded and will be published on eShape website. If you want to open here, why can't I? Okay. So this webinar has been prepared with the support from Francesca and Sandra Cabrera Alvarado from ERSC. OGC in eShape is in charge of implementation, and Francesca and ERSC are in charge of the upscale and adoption of the eShape outcomes by the community. And here we will introduce the Earth observation open license compliance and challenges for the eShape pilots. And of course, this can be useful to any type of Earth observation application, as said before. So just some numbers about eShape. We are 69 partners. We were 55 at the start, and we have onboarded 14 more during the life of the project. And we developed 37 pilots distributed over 7 thematic showcases, which include agriculture, biodiversity, disasters, health, water management, climate, and energy. And at the start, it was 27 pilots, and now we have added onboarded 10 more. This is a 4-year grant project. We have started in 2019 and we will end in 2023. So the goal and the activities of the work package I am leading, the implementation, is to support the development of all these pilots, to monitor the progress of all the long life of the project, and then to capture knowledge into final best practices. That would be one of the major deliverables of the project. And of course, considering the support, at the start of the project, we have made a survey to understand which were the outcomes of the initial, of the different partners to develop the pilot, and we call that the initial assessment. And we did that because we wanted eShape to be definitely a user-centric project, and developing user-centric approach for everything. In this case, the users are the Earth observation developers. Of course, we can consider the end users of this application, but this is done by another work package who works on the co-design of the applications. The users for the work package 3 for the implementations are the Earth observation developers. And among the expectations they have expressed from the initial assessment, one of them is the legal aspects. They wanted some support on that. So we have worked on the other ones too, but today we want to focus on this one. And why is it the good time to do that in eShape? It's because we have developed several tasks and several activities, but now we are starting the last year of the project, and a lot of pilots have already developed some results, data, services, mobile applications. There are already several outcomes which are ready. And what we want to do here is to support them to publish their results in several portals and give all the good conditions for these results to be adopted and used. So if we want to increase the audience of the result and the outcomes of eShape, we need to publish on different portals. because each portal targets a different community. You have GEOS, which is one portal, but you can have portal for agriculture, you can have a portal for geobond, for biodiversity, and so on. And so targeting several portals using standards can help increase the audience. Another way to increase the uses is having a fit for purpose and efficient license, because we have learned, for instance, with Google, when we use images and so on, we have learned that we have to pay attention to the license. And if there is no license, we might not dare develop a business and something which would be critical for our activity on something where we do not know the license or we do not understand the license. And this is why having a good license and that fits the business model you want to develop and that respects the credits you have to give to the input data is very important. And then one of the goals of eShape is also to speed up the transition from research to operations and to business. And recently, with the support from ERSC, we have developed a survey, a data survey, asking the pilots which were the licenses of the input data they were using and which was the license they were planning to apply to their product. And we have discovered that several pilots still didn't know the license they could apply, and that the available resources on licenses are not really targeted to the complexity of Earth observation and of the complexity of the workflow, because you usually chain data that you combine with software and so on before delivering your final results. And this can be a whole workflow of components that can make the usage license and rights more complicated. And I was previously involved in ERSC2 in NextGeos, and one of the first findings was that managing correctly the credits was really critical, in particular for research data providers and for in situ, because in situ data are much more distributed and much more heterogeneous. And so I thought that in a time where the Commission and a lot of people in the community, GEOS included, want to encourage, advocate for in situ data sharing, it's very important here for eShape to acknowledge this message and these lessons learned from NextGeos, managing correctly the credit. And so the idea of the survey and of this webinar today is really to raise the awareness on licenses to support fair results publication. Why fair? Because we want the results to be findable through several portals, but also accessible with a good license that encourage the access, interoperable and reusable. If you want your data, your products to be reused, you need to have a good license and clear license. So as said before, eShape has developed, is implementing 37 pilots, which has various outcomes. This can be data, it can be services, it can be mobile applications. And what we have seen preparing this webinar is that we cannot cover everything into one webinar because it would be too complex. And again, to be user-centric, we want to be pragmatic and to apply to what is really needed and accessible, understandable, and usable by our partners. So we decided to build this first webinar focusing on licenses which are applicable to Earth observation data products, meaning that here we exclude services because licenses for applications is different than licenses for data. And the product license you might wish to attach to your outcome will depend, of course, on your business model, but it will also depend on the input data licenses restriction. And this is why the webinar agenda today will include two major presentations, and then we hope a lot of discussions that will come from your experience and the question you can have, again, to be user-centric and to design this webinar as a user-centric webinar. So the first presentation will be by Danielle Kenta, because I have here very, very much simplified based on the preparation of the webinar, two branches. One where the application will produce data which relies on open data products such as Copernicus, Landsat, and so on. And the other one where it can be a bit more complex, because usually the pilots do not use only Copernicus, they also use private data, which can have more complex licenses. And so this is why the first branch, talking about Copernicus, will be presented more by Danielle Quentin from DG DFTS, and he will introduce the Copernicus licenses and their impact on the credits and the downstream licenses. And then we will have Gert Daters, who is a lawyer and partner with BHO Legal, who will present the licenses for EU data products in a more general approach. This is the end of the introduction. I think it's better now to give the floor directly to Danielle, if you are ready, Danielle. So I will stop sharing my my screen.
No, Marie-Françoise, please you can leave your slides.
I can leave it, okay.
Sure, with your diagram. Anyway, I will start. So I'm Danielle Quentin. I'm working at DG DFIS on two types of activities. The data policy, and this is every time we have a new regulation, every 7 years, we are refitting the data policy. Doesn't mean that it changes, but that as we have a legal instrument for program, and it depends on the financing, we are using it to put the data policy for Copernicus. It is the same data policy has been used over 3 iterations of such regulation. I'm also dealing, and this is completely separate, on platforms like the DIASES and also their future. This is more on the infrastructure side. So for the data policy, now I think it is well known to you. For Copernicus, we are enjoying a free, full, and open data and information policy. In Copernicus system, we see data from satellite and information from the services which are using the data from the satellites and different sources to produce value adding. So we have both situation, data stream coming from the satellite, and then the different information coming from the analysis of those data. Both of those information data are free, full, and open. We are providing authorization to the user to do whatever they want with the data, as long as it is legal. It means that they can, of course, use it, reproduce, modify, distribute, communicate to the public, use with other data. This authorization gives them the possibility to distribute, redistribute the data, sell the data if they want, whatever. But there are still some conditions that we would like to see whenever they are using the data. If they are distributing the data as such, they have to indicate that those are the Copernicus data or Copernicus information. If they are modifying the data and putting in value-adding information, then we are asking to indicate that the data or the information has been modified. There is also one thing which is always important in the data policy is the liability or the absence of warranty. There is no warranty on the Copernicus data and information. For what matters when we have the free, full, and open, the full, it's not full in the sense that there could be restriction. There could be the restriction on security. There we have to limit, and this is more, for example, for a specific service that we have using information, which is a security service. Those information are restricted to a specific set of user predefined. Also, the open. Sometimes, as was just said by Marie-Françoise, there are input data, and those input data may have cascading effect on the information to be produced by the services. Of course, we have negotiated all the input data and the license from the input data. We have negotiated with the provider so that we would be able to disseminate the data on our data policy free, full, and open. But it may be the case that there are limitations. And this would be perfectly possible. I was thinking, I'm saying about security, but there could be other perspective. It is still security, still situation, for example, for the awareness of flooding. Member states want to have the information about the warnings, possible warnings of floodings, but they need to manage the alert system to their population, and there is also a restriction of the information. It is provided to the member state, and it is up for the member states to disseminate. So most of the data, free, full, and open, some restriction in specific cases for different reasons. The nice thing is, of course, that we want to develop as much as possible the uptake of those data and allow businesses, public authorities, researchers to further develop and then take and put the license that we want. And that's really a very important part of the freedom for this data policy. This part on the commercialization is always regularly under discussion because we are providing that on a worldwide basis. So there is always concern that this is a European project, and in fact, everybody benefits from it. We do believe that for the environment and for all those very important information, it is worthwhile, but I would not hide that this is a topic that is regularly debated. At the moment, we are in this free, full, and open, and member states regularly support through the adoption of the regulation this data policy. So on those words, I'll thank you. I'm very interested to listen to your reaction and question. I think it is very important because this is, as always, something that can evolve with the technology in the different situation. The precision of the different data and information as we are getting more and more information of more precise information on our environment. Thank you very much. I would be very pleased to answer questions.
Thank you, Danielle. I think we will rather have the questions and answers at the end when we will have the complete vision of what can be the problem, the issue. I give you the floor, Gerd. It should be okay. Perfect.
Okay, now you should see the presentation. Hello, everybody. My name is Gerd Deiters. I'm, as already said, partner and lawyer at BHO Legal. I'm specialized on IT law, data protection law, and of course, due to our focus on the let's say space sector and the spatial industry, we have had a lot of involvement in the Copernicus program and in EU data licensing. Maybe a first remark. You might see the background. I am sending from Bali, and the connection is not always as stable as it should be. So apologies if that does not work as properly as it should do. Um, my presentation comes from a slightly different perspective than Danielle's, because what I wanted to do, or what we at BHO Legal wanted to do, we wanted to give an introduction about what a data license is and what is required in a data license, and how to deal with the issues of data licensing, and that there is a model license which could be used in the future. Um, let's go to the other. Um, mhm. um, so the first question, we have EO data, or we have data in general. You can also say talk about normal data and not about Earth observation data. And the first question which arises for everyone who has data sets which are valuable, what about the ownership rights in EO data, and how are they protected? In theory, a variety of ownership rights might come into play. In practice, copyright protection, the sui generis right on the protection of databases are the most relevant. I have to admit one. Sorry. Um, so, um, sorry for that. I didn't see my own. I didn't see my own screen, so I changed it now. Yeah. Um, so the first question which we have to answer is whether our data are protected by the law. So, for example, by copyright law, or by the sui generis right of the owner or the maker of a database, or if I have to protect the data um, um, with contractual arrangements which are called licenses. Um, to show the importance of this of this question, um, if data are protected by copyright laws, then the user I give my data to needs a license in order to be allowed to use the data. So in such a scenario, which would be the same as for software products, the license is required for the user in order to be able to use the data or the software. If, however, the data is not protected in such a way, then the user can do without another contractual arrangement whatever he or she wants to do with the data. So in case data is not protected by law, the license protects the owner of the data and not the user. So you have to see that a license can come from both angles, and I wanted to share with you some thoughts about that. First question, of course, are EO data protected by copyright? Yeah, first question we have to answer, which oh, now you hear the dog. The first question you have to answer is which law is applicable. This can be a very complex legal issue. However, do not want to to go into this in very much details. Um, what we have to know is that copyright laws may vary substantially by country as regards the question what constitutes a work protected by copyright. This implies, of course, challenges for EO data owners, especially taking into account that data accessed through cloud platforms can be used um, worldwide without geographical restrictions. Under the applicable law, it's always questionable whether and to what extent EO data are protected by copyright, and national copyright laws in general require intellectual creation with a minimum level of originality. So what we have to see is that data collected, for example, from Earth observation satellites do not contain intellectual creation and are therefore in general not protected under national copyright laws. I mean, if you compare data sets with other works which are protected by copyright, for example, books, movies, software, etc., you see there is a difference because the data should show facts, meaning how many people are in a room, how many traffic lights are in a city. These information should not be intellectual creation, but they should be um, just factual data, and factual data in general does not is not copyright protected. However, the processing and value adding steps can be intellectual creation. However, often they are, or in most cases, they are undertaken by automated software applications stored in cloud infrastructures, etc. And there is again no individual intellectual creation. Whether processed data and final products are copyright protected under the applicable law always requires individual evaluation, leaving significant uncertainties for data owners. So what is the outcome of such a finding that for each and every product or data set you would have to make an individual evaluation? If you want to license data to your customers, you can either look into every data set and make a difficult and complex legal assessment whether they are protected by copyright law or not, or you can do something else, which I would propose to do. If you license the data under a license agreement, you do both. You provide or you grant usage rights to the user as if data was protected by copyright, and on top of this, you then provide or you stipulate restrictions for the use of the data or the data products you deliver to your customers, and thus protecting yourself. So from the one on the one hand, you license the data. On the other hand, you set restrictions for the user so that the user cannot do with the data whatever he wants or she wants, if this is nothing you want to do. So if the user should be allowed to do with the data or the data products whatever they want, in principle you would not need a license, but you would only have to say to the users, do with the data whatever you want. However, if as we heard in the introduction, the users as well as the service providers want to have licenses in order to have legal certainty on what you can do, what the user can do with the data. Another question, which is not directly related to the copyright protection, is whether EO data are protected by the so-called sui generis right on the protection of databases. Under this directive, under this EU directive, data arranged in a systematic or methodical way and individual accessible by electronic or other means can be subject to the sui generis right, and such protection is granted irrespective of the eligibility of the database for protection by copyright or by other rights. And under this sui generis right, the maker of a database is entitled to prevent extraction and or reutilization of the whole of a substantial part, evaluated qualitatively, etc., so that the maker of the database is to a very high extent protected. However, again, it is not always sure whether a data set qualifies as a database in terms of the EU database and is therefore protected by the sui generis right. And there, again, I would always propose to say a license should deal with both possibilities, so that it says that if the data set qualifies as a database in terms of the database directive, usage rights are granted, and on top of that, that the license would say that the database or the data set can only be used for certain use cases, which are then listed in the license. I skipped this slides because yeah, I think we should not do this in too much extension. But as highlighted, there are significant uncertainties on the protection of EU data by copyright or by the sui generis right on the protection of databases, and accordingly, owners of EU data are required to protect ownership through appropriate contractual arrangements, and this is typically done through entering into a license agreement. So what we see, and now there comes the problem, the real problem into place. What we see on the market is that there are strong divergencies among existing EU data license. As many public EU Earth observation missions are governed by open data policies, related license documentations are often rather short and only include a limited set of conditions, while commercial owners, operators, in contrast, often employ highly detailed license conditions, often with several variants. We have looked, for example, of the licenses of Maxa, which have and Maxa uses, as far as we know at the moment, 7 different types of end-user license terms, as well as 3 add-on license, and the product terms and the subscription service license together, they comprise many pages of legal terms and conditions. And what the other problem here is that since there is no streamlining of these licenses, they often use different terminology. And since many of the terms which we use in connection with Earth observation data and Earth observation data sets are not legally defined, we have a problem with license compatibility. So if we have data sets from one provider under license A, and then we have data set B from service provider B under the license B, and they use different terms, they use different descriptions for different use cases, then we have a problem when we merge this data together with our data and then provide an added value product. And so it would be very good if there was a harmonization on Earth observation data licenses. Yeah. What we are missing on the existing licenses is a clear reference. Applicable license terms are clearly referenced within the licensing process. We see that there is no streamlined way how user accept license, how the user acceptance is documented, etc., etc. So there is no harmonization at the moment. And what we have done a couple of years, and Danielle was also part of this process then, was that we created an EU data as a service license tool, which had these basic ideas that the diversity of licenses in use complicates the cloud-based, increasingly automated workflows for data search, download, analytics, etc. And legal interoperability would support faster and more efficient processes for Earth observation value adding and service companies, as well as for end users. And so, together with a subcontractor, we developed an online license tool for Earth observation data providers, where we provided boilerplates enabling the production of individual licenses with a given standardized framework. So, to make it short, it was a click license. So you could click through different possibilities, and then the output would be your individual license, which would on the one hand be the individual license of the user who uses or who creates this license. On the other hand, if many users or if more than if users use the license tool, then although they would have individual licenses, the terminology would be harmonized, the provisions would be harmonized, and so this with this license tool you could create licenses which were harmonized in the Earth observation ecosystem. However, this license tool, we have to admit, was not very much used at that time, which was 2018, 2019, and now it is under maintenance because there was a major technical update and upgrade of the underlying system. So we are now working on making this license tool available again. And when we do it and when we publish the URL of this dedicated website, then data providers and also users who just want to do it for fun can go to the website and register. And following the registrations, the data providers can access and use the tool. And then you are guided through the process of creating your license or your licenses. You can make make as many licenses as you want, and the production time we have measured it a little bit is between 30 minutes and 2 hours, and do not require legal experts. And although we are legal experts and as a law firm of course want to have mandates, we know that most of startups and small companies in this ecosystem do not want to spend a lot of fees for legal experts and for lawyers because they do not produce anything. And this tool, because I have seen the question now, the tool was always provided for free. And at the moment, it is also planned that the tool, when it's going to be made available again, is again for free. So you could use the tool without having to pay fees, and the resulting license then could be downloaded, printed, and transferred to the individual institution, company, template, or whatever. The tool itself does not provide a dedicated layout that would have to be done by the users of this tool. And yeah, if many companies use the tool, then we have at least some harmonization among the users, which would then foster a legal interoperability of data sets, and of course would be beneficial for small companies which would not like to let's say pay a lot of fees to lawyers and experts for the creation of licenses. And the tool itself and the license licenses which are created, they apply to data sets, databases, and also data as a service. So we tried to cover as much as of the data products as it was possible under one license. Once we make it available and we distribute the information, you can see that it is a very comprehensive way we designed the license, and that I think that most of or nearly all of your use cases can be dealt with this license. So to make it short now, I just want to wrap this up. First, there are significant uncertainties whether your ownership license, ownership rights in input data are protected by law. License terms are therefore of particular relevance. Divergent license terms may cause serious issues with respect to the legal interoperability of licensing terms when developing datasets, services, or mobile applications within the scope of the E-shaped pilot. bearing in mind that the divergent license terms of the input data, there is no one fits it all solution for complying with such terms when developing dataset services, etc. within the scope of the E-shaped pilot, and usage rights, as well as the licensee's obligations with regard the use of the data are of particularly relevance for assessing how to comply with the license terms in the context of developing dataset services, etc. And overall, open data licenses should not be misinterpreted in a way that the data can be used without any restrictions. As Danielle said before, even if you provide data or you receive data as open data, there might be legal requirements which you have to fulfill, which are not coming from the open data license, but from national law, from EU law, or from other applicable law in the specific case. So thank you for listening to me. Sorry for the inconvenience with the network quality. I didn't see my own slides for a long time. I hope that you saw the slides. And now I would go back to Marie.
Well, thank you very much, Gert. I think it was very interesting because now we are in the stage where we want to publish the results, but we also want to assess, to ask the pilots to assess how far we can upscale these products to other regions to become global. And in this case, we might have to use different inputs. And what I understand is that before going to a business, you have to really seriously assess the rights of use you have attached to the data. But when you move the region and you change the input data, you have to make a full reassessment. So I think this is an interesting point already to identify. I also identified that you would need standards. You know, I work with OGC, and I understand that the licenses are not standardized enough in terms of terminology and structure, probably. So this is something we can think about, but out of E-shape project is not in the scope of the project. And now I would like to give the floor. Yes, I wanted to ask you, Gert, when you talk about the tool and about Earth observation, there is sometimes an ambiguity because some people refer to Earth observation thinking only about satellite data. And in E-shape, we really refer to Earth observation, including in situ, including citizen science with a bigger vision. So is the tool applicable to any type of data?
Yes, it is. I mean, we could also name it a data license. Of course, it focuses on Earth observation data, but as you said, we have to let's say go away from the thinking that Earth observation means satellite data, because also
we are losing you a bit, Gert.
Or pictures or data collected by drones, etc., is Earth observation data. I don't think that we should make that. And the other thing is that if we are talking about Earth observation services, products, and data sets, I think it is very seldom that you only have Earth observation data. You merge the data with other existing data which do not come from the Earth observation sector. So it's not let's say it's not an ecosystem which does not connect with other ecosystems, and the connection of different data from different sources is what makes data and data sets even more valuable. So I would not focus too much on the term Earth observation, but I would focus much more on how to deal with licensing data, because there are licenses which say all data ownership retains with company X, yeah, which is nonsensical, but you read it, yeah. And then on the other hand, you have licenses where there is a very long definition of what data is and how data is protected, etc. And what we wanted to do with a license, we wanted to streamline all this and to provide a framework which can be used and which makes these licenses even recognizable, so that if you read the license and you say, well, yes, I know the terms, I have seen this, and that was the aim. Unfortunately, it didn't work out 3 or 4 years ago as we hoped, but maybe in 2022 or 2023 we can start this project new.
Okay, well, thank you. Miguel Fernandez, you had a question. You can open your mic and ask the question, no problem. I cannot hear you.
I've seen the question. I mean, this is also a question which I think Danielle covered in his or the answer Danielle covered. Yeah, this for highly integrated products that use as ingredients databases that have already terms of use or licenses. Do these supersede the ones of the integrated data sets? Yeah. The question here is always whether the terms which are used for the first licensing. So you have a data set which is licensed from A to B, and B then combines data sets from different sources and then provides the data to its customers. Then it's always the question whether the first data sets which are combined by B, whether they are protected by law, because then this protection cannot be overridden by a contractual arrangement like a license provided by B. However, if there is only a license between A and B, this does not really concern C, so the end user. So the license could, from the legal perspective, supersede the first license from the perspective of the end user. However, this would be a violation of the contract between A and B, and A could then go to B, but A could not. But the first licensor of the data set could not go to the end user and say, well, that's my data. And that depends on the question whether the data sets which are used are protected by law or only by contract. Yeah, and that's a huge difference from the legal perspective. I know that from the technical perspective or from the commercial perspective, you don't want to hear this. Yeah, that this is that there is this uncertainty. But from the legal perspective, these are two completely different worlds. I hope I made this clear, and if not, then please, and I have to try to make it clear in another way.
Oh, we cannot hear you, Miguel. I cannot, at least. Can you hear Miguel? I think there is a trouble with your mic. Okay, he says yes, thanks. Okay. I have another question myself. Do you know when the tool could be, because you said it's under maintenance, do you know when it will be accessible again? Because the project finishes in 1 year from now. Is there any hope that we can assess or try it, or?
I really hope so, because I mean all the underlying technology is there, and the software has been developed. However, there is it was not a project where we received millions of funding to make a tool from scratch. But we had a very limited budget, which and we needed to use the processes of a certain system, and the system has changed. So we have to adapt the processes to the upgrade to the system. And I have to be honest, I don't know whether this would happen in 1 month, 3 months, or 6 months. However, it should happen in the next year, because I mean, you are not the first to ask for such a tool or for such a functionality, and we know that this is very important, and we will have a focus on this. But to be honest, this also goes from our personal budget as a law firm, and we cannot let's say put all the budget we have into the development of this tool. So it will not be something which will happen in the next week, but it will for sure happen in the next year.
Any other question from the floor? You look to be a bit shy. I do not see a lot of questions in the chat. It's really the goal of the webinar to give you the floor.
I mean, maybe I can add something, because we should not we should not focus too much on oh, we have to wait for a tool. If you have data, and you want to protect your own data, and you do not want your customers to be able to do with the data whatever they want, then look into it and do what I said before. Um, don't don't take a software license and just replace the term software by data, because software and data are, from the legal perspective, two different things. And so do what I said, grant usage rights to the user, but then contractually also restrict the use. So, like in terms like the user has the company A grants to the customer the right to use the data for XYZ. For every other use case which is not explicitly named in the prior paragraph, the use is forbidden without without consent of company A, or something like this. So protect yourself by implementing this contractual restrictions, if you want to. If you do not want to, if you want to provide your data as open data and say, well, the data itself is not valuable, it's the timing. So the data, today's data is valuable. Tomorrow it's tomorrow's data which is valuable, and today's data is tomorrow is useless. Then you do not need to protect that. Then you can give away the data if you want to. But if you want to protect the data, make this twofold approach. Grant usage rights, restrict the use. This is not that's not witchcraft, but what we see in 90% of the data licenses, it's done wrong.
You have mentioned some licenses for EO data that can be complex. I call the attention on the fact that many providers have attached different rights to data from different time steps. For instance, you can have open data each 3 hours or 6 hours, and restricted the rights for the time steps which are in between. I say that because several of the pilots are working now or thinking about their business model. And this is a business model that exists. You have some open products and then some which are restricted, either because they have a higher resolution, or in space, or in time. So you can have licenses which are attached to different subsets of your data.
Of course, then this would be two different cases. We know this from also software industry, and we also know this from data providers, that that software providers and data providers, they provide let's say old software, old data for free, while the actual the current data is provided under restricted usage rights, and they are provided for a fee. This is something usual. Yes, we see many software which is provided as open source, which is the software from 2 years ago, and the current version is provided for a fee. But they are provided under two different licenses. Of course, you could also make a license which says that once the data is more than 1 year old, it is you can do whatever you want. However, do you really want to do this in one license? I would not say so, because then the question arises with complex data sets. which is old data and which is new data, because the data sets, they are incrementally, or they are not exchanged from the one to the other moment, but they are amended, etc. So you do not, I don't think you do want to ask the question whether the data which is licensed is data which falls under the open data or under the commercial data license. And so I would draft two licenses and attach them to the relevant data products.
Well, thank you to emphasize that, Gert, because in fact there are two main use cases, well, two main situations, which is real-time use of the data, where a lot of business is happening, and the use of past data, where people did not emphasize so much open licenses, when it would be very, very important now for climate change, because climate change is a different type of scenario and use cases. This needs a lot of data, but which is older. It's usually not business which is developing there, it's more research. And I think it's very interesting to encourage and advocate that the data should be open. Even if you develop a business, you should open your data after a while.
Marie-Françoise,
Yeah.
there's just one thing I'd like to add, and of course, I mean, this is an important topic, and what we have seen with Copernicus is the tendency from a commercial provider to be overprotective over their data. And that could have even consequences on the user foregoing the use of the data, because looking at the license, they see that they will not be able to do what they want. One of the important aspects, and that has been discussed, is the cascading effect of a license. Usually, if you are talking purely into IPR, and we have seen with that we are not fully in it, depending some of the aspects, and that makes the specificities of the data. But when you are in the IPR, you have a full system where at the same time you have the protection of the creators, but also you have use rights for the users. And contractually, some clauses are not possible to protect the user, that they can still do something with what they get. When you are in this data, and if it's only contractual, basically you would be able to be in a situation where you prevent a lot of things that can be done with the data. And I would say this is to the detriment even of the commercial provider. You need to develop your market, you need the user to be able to do it. So a clear, in your license, a clear delineation of to which point it's no longer your license that will cascade and have an effect of the information provided and the license on the value-added product. This is very important, and I'm sure this is one of the aspects of the license, and Gerd talked about those tools. It is to be clear and not to, just because you think that the more protection that you have, you will. No, you want to protect your data so that if you want to protect, if you don't want in the open, but if you want to protect, you just don't want the people to do exactly what you are doing. But then value adding, you need to have the full chain. And to allow those full chains, you need to provide the rights so that these full chains can be lively and the exploitation of the data can continue.
Yeah, maybe I could also add something there, because I fully agree with Danielle, because different from the software scenario, we have to ask ourselves the question: when is data which is processed by another company or by another person still my data? If I have a software and the software is amended, then of course this is the derived product, and it derived work, and it is still my copyright. But where is my copyright if hundreds of data sets are merged together, and and there is a complete new data set? Because the thing is, we are making the same mistake at the very moment which we want to which we want to overcome. We are thinking in the old world of software. or not in the old world, but in the world of software, when we are talking about derived product. From my perspective, there is no such thing like derived data. This is something very different. If data is processed and data and with input data A and input data B, you make data C, which is a complete new information. That is not a derived product. Maybe there is a need to protect yourself, but we are what the mistake what you are making is always you're thinking in a software category, and we should think in a data category, and this is something which has to come from the or from the policies, because this is nothing we can really solve at the moment on the legal level. But yeah, maybe Danielle does not share my opinion or shares. But we have a different scenario, but we use the same terms again. I see it also in the comments. We were talking about derived products. I don't see a derived product there.
But thank you, Danielle, to have emphasized that the licenses can be seen in two directions. And I have introduced the webinar saying that we had to talk about license to facilitate the upscape, to increase the usage. And then we see that sometimes the licenses are considered as a way to close the usage, to restrict the usage. And this is the good balance we have to look for working on the licenses. And it's the tricky point, I think. There is a question from Sergio. Sergio, do you want to ask your question? How can be applied well-known licenses such as Creative Commons by?
Thank you, Marie-Françoise. Yeah, often when I browse data, I see that many licenses are based on Creative Commons licenses, so they can be applied to data produced or not. How they can fit with our activity.
Yeah, that's really hard to say, because I mean, the Creative Commons, they are a brilliant set of licenses. I mean, they helped a lot by creating crowd knowledge like Wikipedia, etc. However, if it comes to data, I often struggle with the Creative Commons, because they are so much in the located in the world where data is per se protected. Yeah, it does not and it doesn't make that distinction that there is something, that there can be something which is not protected. I mean, also from a commercial point of view, of course, it is for a company, it is very hard to understand that the knowledge they produce, that the knowledge is not protected by law, because it's not an intellectual creation. But there I see with the Creative Commons, I struggle with the Creative Commons used for data. But I have to admit that that the last time I looked into this was maybe half a year ago, and I made some remarks. So it's not too present, but I always struggle with the Creative Commons and data.
Yeah, maybe on that one, indeed, and there's been evolution. So I'm not talking about the Copernicus program, because I mean our data policy date back quite a while, and indeed we still have to look at the development. Though on the Commission side, with the open data, there is a use of those Creative Commons attributions and so on. So those are used. As we have been doing a specific data policy, which were encompassing, because of our security and the need to protect some other aspect, and at the time that was there was issues indeed, and with the database directive and so on. So, but there's been an evolution now, and this certainly on our side is part of reassessment that would be needed to look at. And but I'm talking about the Copernicus program, of course. Um, and for the participant, this would be different because those specificities would not be present. So indeed, in your depending, of course, of your project, it is always very interesting to look at those, and in particular for the broad coverage of the different jurisdictions. So this is really a interesting development.
Well, thank you, Danielle. There is a question from Miguel. Miguel?
No, it was not a question. It was just a statement in response to Sergio's question. But I have a comment, and I'm very grateful for these initial discussions on the legal aspects of data in terms of licensing, in terms of use. My question to the E-Shape community and to the coordination would be maybe, what do we do as within the pilots to make sure that we're not infringing the law with our data sets and how we're using them, right? We need a little bit, perhaps more guidance on how to go about doing this, because for us, I am a scientist. I'm an environmental scientist. I'm dealing with remote sensing data every day, but I'm doing this in the research arena. But if you do this transition into data services and derived products, you're starting to get into areas that are outside our realm of expertise. And I think it, at least for us in the biodiversity community, we would appreciate a bit more guidance in terms of how to go about these legal aspects, because we don't want to infringe the law, right? That's the key. Thank you.
Well, this is exactly why we designed this webinar, because we felt that, you know, to develop Earth observation products, you need a pluridisciplinarity. There is a graphics I use regularly from NIST in the US that says to make data science, you need scientists, you need IT skills, and you need mathematics skills. To make an EO product, you need to add some legal skills to that. And so if you're a big company, you can hire some legal experts. If you are a startup, it can be more difficult. You maybe will subcontract some this expertise outside. And this all is about structuring the EO market, which is also what we try to do through these projects, to identify which are the expertise which are needed and how to bring them to the process. It can be hiring someone with the skill, it can be developing the skill. And so the idea of the webinar was to raise the awareness about how far do you need that? Are you in a simple use case where you just need some guidances? Maybe we can bring into the E-Shape best guidances some information about that for the simple use cases. But then at some point, we will not become all of us legal experts. At some point, you need to go to a legal expert if you are in the complicated cases, because we saw that when you merge different types of data and you combine all that, it can become very quick, very tricky. You don't have the same terminologies, you don't have the same structures for the licenses. So the goal of the webinar was to raise the awareness, and somehow asking your question, Miguel, it seems that the awareness is raised. You see, oh, I can do something wrong there. I have to pay attention.
Yes, but maybe if I may step in general, the problem, 99% of the problems with to this regard are the way data is collected, and the second and data protection law. So I think that we have now a broad knowledge with regard to the GDPR. We have all our DPOs. We have our data protection authorities, which we can ask. So from the data protection point of view, I think the knowledge is already there. We are not working from scratch here. And the other thing is, let's say, the collection of data is more the problem than the processing of data once you have them. Of course, if we have a license which does not allow us to process the data, then it should be a quick look into the license of the data products you have bought, what the license says, and it should be very clear whether you are allowed to process or not. But the real issues are, let's say you have drones and you want to collect data and you need the permissions, etc. There is where it's most likely that that there is the potential for breaching the laws. But the mere processing of data does not have so many implications. As I said, data protection law is relevant, but aside from that, there are not so many laws which hinder you from processing data.
Well, what we really have to work on, because I know it's difficult, is to go from research to operations. And this transition is really hard, and we need to bring the minimum support to avoid making it more complicated. We have to facilitate this transition, and this is what I will focus on, I think, in the future of the communication of the works, try to see how we can help the researchers that want to reach the business. I think it's super important.
One initiative, at least in Germany, is about data sovereignty. So that you implement processes to collect information on the data you have and on the data you collect. So what is very clear for every company, if you buy computers, if you buy software, you put every article into a list, and you have an inventory of your assets you have at your company. But what about data sets? What are the data sets? Where do they come from? Did I collect them? Did another person collect the data? Were there any contractual restrictions? That is in general very poorly handled, and to establish a process to be able to see what data comes from what source is key, I think. Yeah, because then if you know there is a data set which comes from a commercial data provider, and you have bought the data under a research license, then the research license will tell you that you can do for research purposes as much as you want. But once you go commercial with your product, you would need to upgrade your license to a commercial license. This information is key. You do not want to violate the license terms, but maybe you do not know them. So what I would suggest, and what I always suggest, is that the first thing to do is establish a data inventory with all relevant information, where the data comes from, what you are allowed to do with the data, and what you have to do if you go from research to commercial, because that's the real issue. If you buy data for research purposes and then you want to go commercial, then the data licenses may tell you that you have to upgrade your license, that you have to pay additional fees or whatever. But this information is really key. And then for each and every data set you collect in the future, you need just this information. What is the data about? Where does the data come from? Under which terms is this license? What can I do with the data? And if there is a question mark, raise the question mark. And so you know that once you use the data for a commercial product, that you have to look deeper into this data. But as I said, I really struggle to understand why everyone knows that you have to make an inventory of your assets, but data are not considered as assets in that regard.
So this was exactly the scope of the survey, the data survey we have done. So for the e-shape pilots here, if you have documented the data survey, you have made half of the work, okay? There is a question from Sandra. When can disclaimers be applied to EO services or products?
Yeah, let's say that's my favorite topic, because what you see in many licenses, whether it's software or data or whatever, you see these Anglo-Saxonian terms like the product or the data is provided as is without any warranties, etc., etc. That's something which you read in so many licenses, which would be under most European jurisdiction void, because when you provide data or a product under general terms and conditions, then the laws on general terms and conditions applies. If, for example, the Commission decides in a data policy that they do not want to provide warranty for the data, then they can do it with a legislative act, and the reasoning of general terms and conditions does not apply to the provision of data by the Commission to the community. But when you provide data or a product to your customers, you have to look into the relevant law on general terms and conditions. And in most jurisdictions, you cannot make this vast disclaimers, but they are in general also not necessary. What is much more important than disclaimers is comprehensive service or product description. If you describe your product in the proper way and you provide what you described, then there is just no link to any warranty. If you, however, go the American way and first you have 2 pages in your general terms and conditions or in your product description saying that this is the best product in the world, you can do everything with the product, and then after two pages of praising your own product, you say, but I do not warrant for anything, then this does not work under the law. So what is key is that the data, the service, the product you provide, that you describe it properly so that the customer knows what the quality is. Of course, if we are talking about satellite data or data collected with drones, if the weather conditions are bad, the data might be bad. But if the customer knows that, and you have to tell the customer when data is collected under bad conditions, then there is no reason why you should be liable if the data is bad, because that's the way how data is collected. A sensor is only as good as the conditions are in which the sensor operates. But if you, of course, say that it's the best, the most accurate, and blah 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 blah, and then you say, but I don't provide warranty for anything, yeah, that's your mistake.
Well, this was a very interesting use case, because it can impact any downstream product.
Yes,
the
of course.
data is cloudy. Any more questions? We are reaching the end of the webinar, time which was allocated.
Can I ask something?
Yes.
Besides you, do you think that in terms of numerical weather prediction, which has a bigger amount of inaccuracy, let's say, because it's not an observation, it's a forecast of the future, do you think that there might be a reason to be even more cautious in terms of disclaimers and you know, the framework that you provide to your customers? Because typically, you know, yes, we have a disclaimer in the form of the American way that you mentioned, which is National Center for Environmental Protection, that says that this is a scientific product, and we cannot be liable, you know, for any cause that might provide. But since we've opened this discussion, it's interesting to be, you know, more cautious upon these matters.
That always depends on the situation. if, for example, you are contracted by a customer, and the customer says that that it would, let's say, rely on your expertise for future investments, etc., and then you provide a prediction which precisely says that and that and that will happen, and then in your general terms and conditions it says, well, but we don't warrant for anything. That does not work. You have to be cautious with the information you provide. Every time you receive a memorandum or a legal assessment, a technical assessment or a legal assessment, then you see the real disclaimers. And the real disclaimers are that if we're talking about forecasts, that a forecast is only one plausible of many plausible or implausible situations, but that this is the situation which you forecast. And then if this forecast does not materialize, then that's the nature of such a process, and I do not see any liability unless there are let's say really methodological errors have made.
I've lost you a bit, Gerhard. I don't know if it's me or you.
Yeah, we lose you a bit, Gert.
You did not rely on the proper processes, etc. But to be honest, if you explain to a customer that how the forecast has been let's say developed, and what the constraints are, and that there are of course other scenarios which are likely but not as likely as this forecast, then I do not see a reason for liability. Yeah, the liability always arises if you praise your product in you cannot really handle your own appraisal.
I see. No, it's good that we are on the same page here, because as you say, it's different to offer an erroneous forecast because of the physical matters that we have exhausted. We have made every effort, but there are physical limitations as to what you can forecast. And it is different because of your own, a wrong configuration or something like this. It's a completely different thing. So these aspects must be clearly denoted in the MOU, as you say.
That's very interesting indeed, and I like the approach, of course, of that. But what has always been the case for measurement is also the accuracy of measurements. And to explain that it's not an absolute accuracy in the measurements, but also scientifically that you can calculate that. It's with Earth observation would have always been very interesting to have with the metadata, some kind of information about that. And of course, with the model, it gets more complex because then you have data with different accuracies getting into it and so on. But indeed, explaining, but even scientifically, it is very interesting for the user to know the reliability. It's needs to be built up. It's complex, but very interesting to provide and to cascade as information.
It is an important topic because based on my experience working with the French Weather Service for 30 years, when the impacts of the weather are very critical for some businesses, they regularly go to court, and the Met Services have to demonstrate that the information that provided was the best that could be provided at the time where the events happen. So because afterwards it's always easier, you know, when the time is over, then of course you can make a better give a better information when it's over. When you forecast, you have an uncertainty, and you just have to demonstrate that this was the best you could do at the time. which is not always easy. Any more questions? We are over the time, but maybe we can take a very last question, if any. If not, our plan was to make a survey after the webinar to get a feedback and see if it could be useful to follow up maybe with one on software, or if we stop here and then let that to another project, which follow-up we can give to this webinar and get feedback again from the users, again, to make sure that the next progress and the next steps are user-centric. If there is no additional question, no comments from the speakers.
I mean, if it is the end, I would really thanks everybody. I mean, this is very interesting topic. Please continue and send information, questions. As I said, I mean, this is of course evolving, and it's always interesting to understand better downstream and the issues faced by the downstream.
Yes, and to connect the real users, which are in face of real use cases, with the upstream expertise in a complex environment. Well, thank you again to all the participants, and thank you to the speakers. We will encourage again the eShape pilots who could not attend to listen to the recording. And we will very much appreciate if you can document the survey we will send you soon. And then we will keep in touch. And of course, we will inform the speakers about the results of the survey. Thank you very much.
Thank you very much. Bye-bye.
Thank you.
Bye.
Bye.
Bye, everyone.
Bye-bye.
Thank you. Bye.
Bye.